Ghislaine Maxwell's fate could be in a jury's hands as soon as today. Closing arguments are happening today in federal court in New York City. The socialite and former associate of Jeffrey Epstein is charged with grooming and recruiting young girls for the disgraced financier's alleged sex trafficking ring. If convicted, Maxwell could spend the rest of her life in prison. So I want to bring in Rikki Klieman to break down the case for us. There have been a number of high-profile cases going on across the country, and so it's been hard to kind of keep up with everything. But now with the Ghislaine Maxwell case, we are going to be hearing the summation of the arguments on both sides. What can we expect to hear from both sides during closing arguments?
What you're going to hear, Anne-Marie, and good morning and happy holiday season to you, is what you're going to hear during this holiday week. Our closing arguments today that are really expected to last many, many hours, followed by jury instructions, and the court will sit as late as 6 p.m. today. So what is the prosecution trying to do? The prosecution is looking at its 4 alleged victims and saying, all you have to do, members of the jury, is believe them or even believe one of them. You have 4 women, now adults, who all tell a similar story about Jeffrey Epstein being a serial sexual abuser of minors, some as young as 14 years old. But going to this defendant, Ghislaine Maxwell, what they are saying from the prosecution side is that without Ghislaine Maxwell, these girls might have never gotten to Jeffrey Epstein, that she was the one who enticed them. She was the one who groomed them. She was the one who made them feel comfortable enough to go into that massage room and to be abused by Jeffrey Epstein. Interestingly enough, it does not stop there from the prosecution point of view, because some of these 4 now adult women, then teenage girls, say that Ghislaine Maxwell actually also sexually abused them. So the prosecution's case is very clear. It's very simple. They're looking at these 4 witnesses corroborated by other witnesses, but it's a lean case. And I think that that was very smart. We don't have to try Jeffrey Epstein here. He is dead. We have to try Ghislaine Maxwell. So, Anne-Marie, what does the defense do? The defense opened by talking about what they called the 3 M's, that what the case was about, according to the defense, was about memory, the fallibility of memory. So you have memory, you have manipulation, according to the defense, that is being manipulated by the government, and you have money. So money, because the defense is saying that what these then young girls, now adults, are doing is they're putting Ghislaine Maxwell as an equal participant with Jeffrey Epstein, because that's what the government wants them to do, and it enhanced their claim value in the Epstein Epstein Victim Fund. So you either believe one side of this or the other, or perhaps put more like a lawyer. The burden of proof is on the government to prove the case beyond a reasonable doubt. So did the defense raise enough doubt in their cross-examination of the witnesses, plus the witnesses they put on, to attempt to show that the 4 women were not telling the truth?
So there is the narrative of, the role that you believe Ghislaine Maxwell may have played and the type of relationship that she had with Jeffrey Epstein. But then there are the actual charges that she's facing, and that comes with a very specific definition. So can we talk about the charges that she's facing and the sort of factors that the jury will have to decide on to come to a conclusion?
What you're looking at here is really 6 charges, or are really 6 charges that are before this jury. And they're very specific, but they go around the same factors basically for each of the charges. By the way, altogether, she's facing what is in essence a life sentence, because she will be 60 on Christmas Day, and there's a maximum penalty, if you counted all of them up, of 70 years. So what you're looking at are charges of arranging the travel for these teenage girls to have illicit sexual activity, for enticing the girls into going into the travel for this illicit sexual activity. And ultimately, the big charge is trafficking of minors in sexual activity. And the trafficking charge is the one that really usurps all of the others because they all fall within this. There are very few people who we look at as traffickers of youngsters in sex. And that is really a painting over all of the charges beneath. And the elements of each charge then really become elements in the next charge, except you may add an element like conspiracy. But this is a narrative, as you put it. The narrative is, from the government's point of view, that she is an equal participant. She is, in essence, a madam going out to find these young girls, seeking them out, grooming them, making them feel comfortable because she was an adult female in the room, to normalize the activity of having sex with Jeffrey Epstein and perhaps other men.
So there was a conference Saturday to go over jury instructions ahead of closing arguments today, and I thought this particular point was quite interesting. The judge said that the jury will be able to convict Maxwell if they find she willingly avoided knowing about Jeffrey Epstein's alleged encounters with the young girls. That was interesting because there were, the individuals who testified in her defense who worked there who said, I never saw anything, illegal or anything sort of go wrong. In fact, a lot of people have said, I noticed that there were young girls, but I never saw any bad behavior. I'm just curious, what this says. What does that jury instruction tell you?
Well, the jury instruction tells me that the prosecution is going to find a way to convict Ghislaine Maxwell one way or another. This is a jury instruction that is particularly suited to the Second Circuit, which is where the Southern District of New York is. It's a jury instruction that is not common because what it really is like willful blindness. That is, I found this young woman. I brought her to the house. I took her shopping. I took her to the movies. I made her feel comfortable. I opened up the door of the massage room. I walked her in and I left. That's a far cry of greater involvement than the witnesses who testified for the defense, who were basically in the office. They were not in the homes where this sexual abuse allegedly occurred. So can Ghislaine Maxwell escape responsibility by saying, I told the young girl that she had a body that Jeffrey would like, I walked her into the massage room, and then I left, and then I saw her come out, and she looked stricken. This is, of course, shading it from the government's point of view. Well, can Ghislaine Maxwell then say, I have no idea what happened there, understanding that there's no burden of proof on the defense? This instruction, called conscious avoidance, which started to gain prominence at the time of the Bernie Madoff fraud cases, that we really heard about it as a willful blindness. Can I just simply look the other way and not know what is happening? But it's a big instruction for the prosecution, because if they can't really convince a jury that Ghislaine Maxwell touched any of these women in an inappropriate way of a sexual assault, as some of them testified, and if the government can't convince the jury that she really knew what was happening, it's more that she had to have known what was happening, which gets them a long way toward conviction. Does it become an issue for appeal? Should Ghislaine Maxwell be convicted of any of these charges? You bet your bottom dollar it does.
Before we let you go, Ghislaine Maxwell decided not to testify. She stood up in court on Friday and she told the judge, quote, "The government has not proven its case beyond a reasonable doubt, so there is no reason for me to testify." So I don't know if this is sort of a standard statement that is often made. But what did you make of the statement, and was not testifying the right move in your expert opinion?
Not testifying was exactly the right move. Most defendants, when they are interrogated by the court, as they must be, about whether or not they are making a decision voluntarily, intelligently, knowingly not to testify, and that they do have a Fifth Amendment privilege not to testify, most defendants will simply say that I've chosen not to testify, or the judge says, do you still choose not to testify? And they say, yes, I do, or no, I'm not going to testify. It's very rare to hear a defendant make a statement as defiant as Ghislaine Maxwell's statement was. But I think that it's part of her persona. You can also figure that since Ghislaine Maxwell, at another point in time in 2016, was willing to waive her Fifth Amendment rights and be deposed under oath in a civil suit brought by Virginia Roberts, who is another alleged victim, but not a victim in this case, that she did testify. And what is she facing as a result of that testimony? 2 counts of perjury, not at this trial, because those 2 counts were severed, that is, separated. But those 2 counts are still out there. So even if she is acquitted in this trial, or there is a hung jury in this trial, she's still got those 2 perjury counts to face. So yes, it was the right decision. Her statement perhaps made her feel better. I think that her statement makes no difference except for how the media reported it.
Well, we'll be keeping an eye on the case. Rikki, thank you very much.
Always good to be with you, Anne-Marie.